All right, so President Obama's immigration announcement. It's very important to emphasize at the beginning that the announcement that was made in November is not a piece of legislation. It's not an immigration bill. It's not a law. It's an action that President Obama took basically because Congress, particularly the House of Representatives, has dragged its feet for years on considering and taking up the issue of comprehensive immigration reform. So in essence, Congress left the president, as he put it, with no choice but to move ahead on his own and to announce this executive action. So because this is not a law that was passed by Congress or signed into law by the president, its effect is limited, and we're going to talk about what that means in a few minutes. So what the president basically said is, we have 11 million people in the United States that are undocumented. Because we only have funding to deport 400,000 people every year, we want to be able to concentrate our limited resources on the persons that we believe have the highest priority. We want to make sure that they're definitely deported. So basically, people with criminal records, terrorist ties, gang involvement, that kind of thing. So what this executive announcement allows his administration to do is for the vast majority of the 11 million people that we're not going to target, we're going to defer deportation, and we're going to allow some of them to actually get immigration documents that will authorize them to work and to travel under limited circumstances. So what are the key parts of the announcement that he made? The first part is he expanded something called deferred action. Deferred action is a concept under the immigration law that basically is an act of forbearance by immigration. In other words, a determination that we're not going to deport a person. And so he expanded the concept of deferred action to include, in some cases, parents of U.S. citizens and parents of green card holders. The second major phase of his announcement was to expand the program known as DACA, Deferred Action for Childhood Arrivals, the program that was initially announced 2 years ago that specifically deals with the DREAM Act children. And the expansion of DACA that was announced in November eliminates the age cap, changes the date of entry, and extends the EAD, that's the abbreviation for Employment Authorization Document or work permit, expands the EAD period to 3 years from the initial period, which was 2 years. And then thirdly, and we could talk about this for probably quite some time today, but we're not going to spend any time on this program, he ended the concept known as Secure Communities, which is a program where, in essence, local police cooperated with immigration in enforcing the immigration laws. So how many people are going to benefit nationally from the president's announcement? It's been estimated that 4.4 million parents of U.S. citizens and permanent residents are theoretically eligible nationally to apply for the program known as DAPA, Deferred Action for Parental Accountability. And that approximately another 300,000 people are going to be eligible for the expansion of DACA. So let's talk about what the benefits and limitations are of both DAPA and DACA. The benefits of these two programs are, first of all, persons are specifically protected from being deported for a 3-year period. So if a person applies for one of these and is granted, they will not be deported for at least 3 years. Secondly, they're also eligible to obtain work authorization, which means that they can then work legally in the United States. And with their work authorization, they can obtain Social Security numbers. In New York, they'll also be able to obtain New York State driver's licenses, and under some limited circumstances are going to be able to request permission to travel abroad. So what are the limits of DAPA and DACA? First of all, since it's not a law that was signed by the president, not a law passed by Congress, it's subject to being revoked by the president, either this president or any future president, at any time without having to go through an act of Congress, simply by the stroke of a pen. So for that reason, it's not as solid a benefit as is the case with anything that's passed by Congress. It doesn't provide people with a green card or a visa, and it does not provide people with a path to citizenship. And a person that applies is not guaranteed that their application is going to be approved, because each application is going to be looked at by the Department of Homeland Security, or DHS, on a case-by-case basis, and the decision whether to grant this form of relief is going to be based on what their enforcement priorities are. However, I will say that under the program that was announced 2 years ago for the DREAM Act kids, DACA, just to give you some sense of how that has functioned so far, as of November of 2014, 610,000 young people nationally had been granted DACA benefits, and only 32,000 has had their applications denied. So that's an approval rate of 95%. So chances are, for persons that apply for DAPA and extended DACA, if they are in fact eligible and they don't have any sort of criminal record or immigration history that will disqualify them, chances are that they are going to receive this benefit. But the other thing in terms of limits that people should know is, again, by coming forward and applying, they are exposing themselves to immigration. So that's why it becomes very important for everyone, and in particular people that have some sort of adverse criminal or immigration history, it's very important for them to get some sort of screening, and for folks that have more serious issues with a criminal or immigration background, to get some sort of specific advice from an immigration attorney. All right, so let's talk about what we know to date as to what the eligibility requirements are for DAPA. So first of all, this is all geared, as you can see by this slide, to November 20th of 2014. That was the date the president made his announcement. So as of that date, a person that wants to apply must have had a child that was a U.S. citizen, or is, a U.S. citizen or permanent resident. So if your only child was born on November 21st, you're not eligible. The child must have been born on or before November 20th of 2014. Secondly, the person that wants to apply must have continuously resided in the United States since January the 1st of 2010. The whole spirit of this announcement was to keep immigrant families intact that had some presence or some long-standing connection with the United States. So the administration, as sort of an arbitrary matter, picked a 5-year period. You must have lived here since that date in order to be eligible for this benefit. Thirdly, you must show that you were physically present in the United States on the date that the president made the announcement. The reason for that is that the administration did not want to encourage unlawful immigration to the United States. So in other words, they didn't want to encourage somebody that, say, had been here since the January 1, 2010 date, but had temporarily left the United States, hearing this announcement, to come back to the United States unlawfully, because that would defeat the whole thrust of what the administration, other thrust of what the administration is trying to do, which is not to encourage unlawful immigration to the United States. And finally, this form of relief is geared toward persons who did not have any type of lawful status as of November 20th of 2014. So as of that date, if you already had your green card, if you are already a permanent resident, this is not a benefit that you need to apply for. This is not, as a permanent resident, your status gives you far more benefits than what DAPA can give you. And just to go back for a second about the continuous residence in the United States since January 1 of 2010. What we don't know is how literally the immigration is going to define the term continuously resided. Under the DACA program, it was possible for children that had not continuously resided for each and every day from the date that they were required to have resided in the United States. It was possible for them to still be eligible if any absences from the United States were brief, casual, and innocent. We don't know if that same policy is going to be applied toward DAPA. That's one of the items that we're waiting to get more information about. So what if you have a criminal record or a recent removal order? The announcement that the administration made on November the 20th seems to indicate that if a person has the following types of criminal convictions, they are probably not going to be eligible for DAPA or the expanded version of DACA. So a felony conviction is probably going to disqualify a person. If a person has 3 or more misdemeanor convictions, they're probably going to be disqualified. And if they have, or if they have 1 misdemeanor conviction, if it's considered to be a significant misdemeanor, and under DACA, that was defined as any conviction dealing with domestic violence, sexual abuse, burglary, a weapons offense, drug sale or distribution, a DWI, or any misdemeanor where the person was sentenced to 90 or more days in jail. So for folks that have any of those types of convictions, any kind of criminal arrest, a recent deportation order, which apparently is going to be defined as an order that is post January 1 of 2014, it's very important for people with any type of arrest or any type of prior dealings with immigration to get legal counseling to make sure that it's safe for them to go ahead and apply for this. Because again, if a person applies for this and they're not eligible, then especially if they have a criminal record or any prior history with immigration, they may get placed in removal proceedings. All right, so let's talk about the second benefit that people are eligible for under the president's announcement. The expanded version of DACA basically did two things that were an improvement over DACA 1.0. Under DACA 2.0, there's no age cap. So when the president first made his announcement back in 2012, this was geared toward young people that were under the age of 31. The age cap has now been removed. So theoretically, you could be 40, 50, 60 years of age. And if you meet all the other requirements, the basic one being that you must have entered the United States before the age of 16, and that you have either a high school diploma, a GED, or in some limited circumstances, apply in a job training type of program, you're now eligible even if you're over the age of 31. Under DACA 2.0, the continuous residency requirement was moved up to January 1 of 2010 from June 15th of 2007. And so these improvements will make more people eligible to apply under that. Other important things to know about the expanded version of DACA is that when it was initially announced in 2012, people were able to get deferred action and work permits for 2 years. Now they will get deferred action and work permits for 3 years, and the administration is currently in the process of adding a year to the work permits of anyone that were initially given only a 2-year work permit. And again, just to emphasize the importance of speaking to an attorney if for a person that's ever been arrested or is not sure about their criminal history or who has some prior history with immigration. So for expanded DACA, for people that have DACA now, what does this mean? That, well, their work permit and their grant period is still valid for 2 years, and the administration is trying to figure out how to extend that from 2 to 3 years. And for people that applied after November 20th for DACA, they're going to be getting 3-year work permits. Now, what if people don't qualify for either DAPA or DACA? So as we know, immigration only has funding to deport 400,000 people out of the 11 million undocumented people that are in the United States. So for probably the umpteenth time since 2011, a memo has come out from immigration saying, you know, these are the people we're going to deport: criminal offenders, people that threaten national security, recent immigration violators, also active gang members, that kind of thing. And we're going to kind of take a hands-off approach to anyone that doesn't fall into any of these categories. Now, they've been saying that they were going to take this hands-off approach to anyone who doesn't fall into any of these categories since 2011, and it hasn't really happened. It's happened in limited situations, but has not happened to the extent that a lot of advocates thought it was going to happen. Whether this recent announcement is going to change that, only time will tell, so stay tuned on that. All right, so the application process for DAPA on the left-hand side, it's anticipated that that's going to begin sometime in May, and the expanded version of DACA, that application period is going to begin sometime in February. It's important to note that there is no deadline by which time a person has to file their application. So as long as this program is in effect, people are eligible to apply, although it probably makes sense to get in an application as soon as possible, because if by chance President Obama, which I don't think is going to happen, but if some future president decides to revoke this, my personal opinion is that it'd be very difficult for immigration from a political standpoint to deport anyone who has been granted this type of benefit, particularly if you're talking about deporting young people that have lived in the United States their entire lives, who have gone to school here and who are a credit to their communities and our nations by the academic work they've done and the volunteer work they've done in their communities. And I think even Republicans believe in family values, and to start deporting families who have children born in the United States is hopefully something that not even a Republican administration is going to do. So that's why I think it'll be important for people to get in their applications as soon as possible. I taught beware fraud. This is really important for people to know. And I think even for all of us, there might be a tendency to say, well, you know, what if a person comes to one of our workshops and they give me a document that says that they came to the United States in December of 2009, and then they tell me, yeah, I bought this on the street for 50 bucks. So there might be a temptation to say, you know, that's just between you and me. I'll pretend I never heard that. Let's go ahead and help you with your application. And the temptation is to help somebody that is undocumented, that has no other way of getting immigration benefits. Who's going to know? Who's this going to harm? As a lawyer, I have a legal and ethical obligation. I cannot help anyone commit a crime. And if a person lies on a form that is filed with immigration, they are committing a crime. So I cannot help anyone commit a crime. And in my view, what's going to happen, and we saw this to a great extent in 1986 when the Reagan amnesty law was passed, is that there were people that obtained amnesty, and I'm thinking of farm workers or people that applied as farm workers who said, yeah, you know, I picked blueberries for 3 months and that's why I'm eligible. And then they went to their interviews with immigration, and an immigration officer asked them, you know, well, what equipment did you use in order to pick blueberries? And the person said, I got on this 10-foot ladder to pick blueberries from the blueberry tree. And so what happened is immigration started hearing enough of those stories. They started requiring people who were in fact eligible to provide more evidence to satisfy their eligibility requirements. And as we know, folks that are undocumented, by definition, don't have documents. So it may be difficult for some folks who are eligible for this program to come up with the documents they need to show that they are eligible. So we want to do everything we can to make it possible for people who are eligible to apply and to get approved. But if we then, on the other hand, help people that are not eligible, and immigration starts seeing a lot of false documents, and they are going to be looking for fraud, and they have ways of detecting that, then there may come a point where they'll say, well, okay, at first we said you only need a document for each year to prove residency. Now we're going to need a document for every 6 months or for every 3 months. And then it becomes more difficult for folks. So that's the way that I'm going to operate this. It's going to be strictly on the up and up. If we run into people that are not eligible for this, we'll talk about this in a few minutes. We're going to see if there's some other benefit that they're entitled to. But we're going to help people that are eligible by the letter of this announcement. But in any case, there may be people already out there saying, oh, you know, give me money, I'll help you file an application, you know, we'll walk it over to immigration tomorrow. There's nothing that people can apply for yet. And don't believe anybody that says that they can sign you up for a program now. So the important thing for people to do at this point is to prepare and stay in touch. So there are a couple of things we know about the application process itself. The form is not available. The fee is going to be $465. And as was true under DACA, it's going to be very difficult. It's going to be possible, but very difficult to get a fee exemption or a fee waiver. And we don't know specifically what the policy is going to be for DAPA yet, but that's something that we're going to be finding out in the coming months. People are going to need supporting evidence, which we'll talk about in a few minutes. And anyone that applies is going to have their fingerprints taken and their background checked. Another reason why anyone with any type of criminal or immigration history needs to talk to an immigration attorney before they apply. So what can people that think they are eligible do now in order to get ready? $465 is a hefty sum of money for folks. So start saving money for the application fee. Gather evidence to show that they qualify. Get together any criminal or immigration records that they've had if they've had prior run-ins with the police or immigration. Consult with an immigration lawyer or a BIA accredited representative. Two more things. Do not go to immigration. Don't go to immigration and say, I'm applying for DAPA, because depending upon what your history is, you may find yourselves in removal proceedings if you do that. And do not leave the United States under any circumstances, because continuous presence is required from November 20th of last year to the date that the president made his announcement on. So gathering evidence is one of the things that potential applicants can do to start preparing. So what do they have to prove? What do they need evidence of? First of all, they need proof of who they are, of their identity. And the documents listed are some of the types of documents that are probably going to be acceptable. In essence, folks are going to need some type of photo ID. For citizens of Mexico and Guatemala who do not have photo IDs, the Mexican and Guatemalan consulates from New York City for the past several years have been coming to this area in the spring and summer to issue passports and documents called matricular consulars to citizens of their countries. We don't have any dates for those consular visits, but for citizens of Mexico and Guatemala who need identity documents, that would be one way of getting them. People are also going to need to prove that they have a child that's a U.S. citizen or permanent resident. So birth certificate of the child, if the child was born in the United States or if the child was born abroad and has a green card, is going to be essential. A copy of the green card of the child if the child has a green card. If the child was not born in the United States but was naturalized, a copy of the child's naturalization certificate. If the child was adopted or if the child is a stepchild, then you'll need either the adoption decree of the child or the marriage certificate if it's a stepchild. And under immigration law, and we don't know yet specifically how immigration is going to define the term child for purposes of DAPA, but if under the way immigration law is currently written, if you marry a child's parent before that child is 18 years of age, then as that child's step-parent, you then become eligible to apply for immigration benefits through that child. We don't know if they're going to use that same rule of thumb, but if they do, that's what the current rule of thumb is. Probably the most difficult piece of evidence for people to come up with is proof that they've continuously resided in the United States both for the last 5 years, and they're going to have to show that they were actually here on November 20th of 2014. Now, with respect to that specific date and proof that they were here on November 20th of 2014, again, we don't know how immigration is going to define that, but if they define it the same way they did under DACA, they did not require people to have a document with that specific date on it. So they were pretty liberal about that. So under DACA, the specific date was June 15th of 2012. If you had a document that showed you were here in May or in July or possibly even April or August, as long as you had enough documents showing you were here leading up to that date, a document that did not specifically fall on the date they wanted was accepted. Will they do the same thing under DAPA? Hopefully, but we have to wait to see on that. So what types of documents are going to be acceptable to prove continuous residence? The PowerPoint gives you examples, but the general rule of thumb is any document that has your name on it, the date, and has a U.S. address on it, hopefully will suffice. But these are just some examples of some types of documents that should be accepted by immigration as proof of the continuous presence requirement. And then finally, if people simply don't have anything at all, but because they're applying for this, they have children that were born in the United States, hopefully their children have documents that show that they've been living in the United States, school records, medical records. And if any of those school or medical records have their parents' names on them, then applicants should be able to use their child's documents in order to prove the continuous residence requirement. Criminal history. So there may be folks that come in that will tell us that they've been arrested by the police. And if they have documents that show what happened, that's the ideal situation. We're probably not going to have the ideal situation in each and every case. People are going to say, the police stopped me 3 years ago. I was in jail overnight. They let me go. I paid a bond, and then I never went back to court again. So in that situation, we, and specifically I, am going to have to figure out what actually happened. Do they have a conviction? Do they have an outstanding warrant because they didn't go to court? And there are ways to get people's records from the FBI, and in some cases, if people can remember what court that they were in, to get the record from the court itself. So for more resources and to keep up to date on what's going on with DAPA and DACA, the primary source of information is the website for U.S. Citizenship and Immigration Services. The web link is listed on that page, as well as the specific page for DACA. And there's even a feature that you can use to give USCIS your email address to get real-time updates from them on developments in DAPA and DACA. People can register with United We Dream. I don't know if they're going to have DAPA updates, but another source that is the source that provided this particular PowerPoint, is a website called adminrelief.org, which has a lot of those helpful legal resources on it. And adminrelief.org is basically a collective effort of all the organizations listed on this page. Basically, all the legal or the leading immigration legal services providers nationally came together and said, you know, instead of reinventing the wheel, instead of having our own intake form or frequently asked questions form or PowerPoint, let's all join resources, do common forms that everybody can use. So this is going to be a wonderful resource as we move on with this. So that's the end of the PowerPoint.